This week on the Communicators, two viewpoints on a legal decision this week that rejected the FCC's policy on broadcast indecency. Attorney Carter Phillips represented Fox television stations. Patrick Trueman filed a friend of the court brief for Focus on the Family and Family Research Council.
And from the U.S. Second Circuit Court of Appeals decision this week, we now hold that the FCC's policy on indecency violates the First Amendment because it is unconstitutionally vague, creating a chilling effect that goes far beyond the fleeting expletives at issue here. Carter Phillips, you are the lawyer for Fox television stations. What's the net effect of this decision on indecency?
Well, I think it takes the law essentially back to Pacifica, where the Supreme Court said
the Carlin decision.
The Carlin decision, the 7 dirty words. I think what this says is you should be looking for that kind of shock treatment, repeat statements as a basis on which to enforce indecency. Obviously, the Second Circuit would not have the authority to overrule what the Supreme Court had said. But I think basically from that point forward, what the Second Circuit says is that the rest of what the Commission has done here is just so, as it says, vague, so incomprehensible that it's not a basis on which the First Amendment will allow you to enforce the indecency standards.
What are some of the other decisions that have been made since the 1978, I believe it was, Pacifica case?
Well, on the question of indecency, obviously the Internet, there were a series of Internet indecency cases which actually follow standards that are very similar to the standards that the Commission was using for indecency in the broadcast area. And the Supreme Court has consistently struck those down. But the question has always been, is there something fundamentally different between broadcast media and other media like cable or like the Internet? And the Court of Appeals didn't say that you treat the media, the broadcast media, the same as all of the others, because it said the Supreme Court's going to have to tell us to do that. But what it did say is that broadcasters are entitled to the same reasonably clear criteria so that they can structure their broadcasts in a way that doesn't force them to end up running afoul of the indecency standards that the Commission has adopted and expose them to potentially ruinous fines.
Carter Phillips is the attorney, was the attorney in this case for Fox television stations, and also joining us on the Communicators is Kim Hart of the Politico.
Hi.
Hi, Kim.
So in the decision, they bring up that we face a media landscape that would have been almost unrecognizable, they say, in 1978. How do you see this evolving media landscape that is changing almost on a daily basis, where there are countless more outlets, a ton more opportunities for entertainment like this on the Internet and cable and broadcast? Where do you see this discussion evolving, and what's next for broadcasters?
Well, you have to remember that when the Supreme Court decided the George Carlin case, Pacifica, one of the reasons it came out the way it did was because it said that broadcast television was uniquely pervasive. And what has happened in the 30 years is that broadcasting has become anything but uniquely pervasive, because virtually everybody has cable, and I would guess that most young children can't tell the difference between whether they're on a cable channel or a broadcast channel, because they're just doing it from a remote. And obviously you have the Internet, and there's the sort of oddity of if you were to broadcast it under the traditional standards that the Commission used until the decision came down, and you would bleep out words on at broadcast, you could then get on the computer an hour later, watch the exact same show, and of course wouldn't be subject to any of the bleeping. So the media have all converged in a way that makes singling out broadcasters for disfavored treatment, to my mind, completely unjustified. And, you know, that would be the next step, I think, if this case continues on to the U.S. Supreme Court. I think that's an issue the U.S. Supreme Court would have to deal with.
Was that one of your arguments?
We made the argument, but we recognized that it wasn't really available to the Second Circuit to say things have changed. I mean, they're not permitted to overrule Supreme Court decisions. So, but what I thought Judge Pulu did a very nice job of describing just what you described, which is show how things altered so dramatically and kind of tee it up if the Supreme Court wants to revisit it. And the important thing about this is that, you know, the Supreme Court upheld the FCC's regulatory authority in the 70s and 60s, 70s, and, you know, there was a very different world out there. And the question of whether or not the Supreme Court today would uphold the same regulatory authority in an environment that has changed that dramatically in 30 years seems to me to put the Commission at some risk of losing a significant amount of its power.
Well, along the lines of the FCC's power, you know, the indecency was clearly a priority under Kevin Martin, under the Bush administration, and it hasn't really been considered as much of a priority under this new FCC regime. Where do you see the FCC going with this? What do you expect from the Commission?
Well, I thought that the chairman's statement when the opinion came down was quite tepid, and you have to balance the interests of children, families, and the First Amendment. I suppose that's literally true, but it doesn't really give you a lot of guidance as to how he's going to strike the particular balance.
Right.
And I think I don't think you can read too much into the fact that the Commission hasn't done a lot of enforcement since the election, in part because the FCC's got a lot of other irons in the fire, but also because this litigation has been ongoing for quite some time. I think the Commission's been somewhat constrained in how much it wants to invest resources until it knows for sure whether or not there's going to be a problem.
Carter Phillips, the Second Circuit only addressed a small portion of the indecency issue. And the Supreme Court, when you look back at the history, it seems to have always kind of punted on establishing indecency standards. Is that true?
Well, the court has recognized that the Supreme Court has recognized that it's very difficult to define indecency, and so in general it hasn't had to come up with anything because it's been able to say basically governments aren't allowed to regulate what is indecent. In the media, where they have had the opportunity to do some of that regulation, I actually thought that I would read the Second Circuit's opinion as a somewhat more sweeping one because it not only says that fleeting expletives are permissible, but it also much more broadly analyzes scripted television and says, look, you can't know. You can't know if you're going to show Saving Private Ryan as opposed to a documentary on the blues. You can't know ahead of time which one of those is permissible, even though those are not problems that arise on the air in fleeting style. Those are scripted, and so I think that actually the Second Circuit's decision is a quite broad one for purposes of saying, no, we're not going to allow this any longer.
And in fact, the three judges wrote this: the English language is rife with creative ways of depicting sexual or excretory organs or activities, and even if the FCC were able to provide a complete list of all such expressions, new offensive and indecent words are invented every day.
And so the question is, do you just give up this task, which is what I would hope, frankly, that the Commission would do, or go back to where it was 30 years ago and recognize that there may be very extreme situations where there's something that you could describe as indecent. Although I think if the Pacifica Court were reviewing that issue today in this environment, I don't think they would have come out the same way. And we'll see whether the Supreme Court does, or whether the Commission asks them to, for that matter.
What does this mean for nonverbal content?
Doesn't say much about nonverbal content. There is some language in there that gives that is concerned about sort of what images you can show and which ones you can't show and how to play that. But from the Second Circuit's perspective, that one they didn't have in this particular case. I think they're going to have to wait till either Janet Jackson comes out of the Third Circuit or the NYPD Blue comes back out of the Second Circuit.
And does this mean that broadcasters are free to kind of let up and just kind of let whatever flies fly on air between 6 a.m. and 10 p.m.?
Well, I think for fleeting expletives that the answer would be yes, that you don't have to sit there and try to scrutinize every sporting event to make sure that you don't have some slippage of a word here and there. I think it's important in that context, though, to recognize that broadcasters have had the right for years to use expletives freely in the period, in the hour between 11 o'clock and 6 a.m. And yet, if you watch television during that time, you don't see a lot of it. You know, ultimately, the broadcasters have a responsibility to their audience, and they're going to behave accordingly.
Have F-bombs been dropped on
Very rarely.
broadcast television? I mean, between 11, just kind of gratuitous ones?
No, they haven't done that.
But they're allowed to legally?
Oh, yeah, they would have been perfectly permissible.
Then why haven't they?
I think because they recognize that you're going to lose, you will lose more of your audience by offending them than you will gain by the occasional F-bomb that might get some traction with the audience. And particularly if you're thinking about sort of late night and who's watching, et cetera, they're probably not going to get all that excited about it one way or the other.
And this does seem to kind of single out the F-bomb in a way as being the target of some of this attention. Do you think that, why do they single out that one? I mean, there are plenty of other vulgar words.
Well, the commission says that that particular word invariably connotes sexual activity, which is counterintuitive to me, but that's the position they've staked out, and for that reason they've made it the sort of primary push as far as language goes.
In this decision by the Second Circuit Court of Appeals, they used the word chill or chilling throughout here. Why is that?
Well, the problem is if I don't tell you what the standard is with sufficient clarity, and then you're trying to stay within the line so you don't end up being exposed to $325,000 fines per station that broadcasts, what are you going to do? You're going to end up broadcasting in a way that keeps you very far from the line, which means that you're going to self-censor. You're going to take out language that probably would have been okay, but you're not going to take that risk. And the best illustrations of it, I mean, the opinion has a number of them, but the refusal in Vermont to broadcast a debate between two political candidates because one of the candidates had been known to use expletives. So that's, in that situation, I mean, that's a political debate. You would hope that would be the one core First Amendment protected value that you would most want broadcast media to get out there for the American people in order to help them decide who should win a political election. And yet, one of the stations walked away from it.
Carter Phillips, you got the decision you wanted at the Second Circuit Court of Appeals. But what was the reason for pursuing this if the networks don't already use language that they're permitted to use after 10 p.m. and if you don't think it's going to really change the face of the network broadcast?
Well, it does two things. There are two things about it. One is this places enormous pressure on live broadcasting because if the previous regime did. That is, you had to monitor, you had to have delays, and the truth is you were never going to have a system that was 100% accurate, which means it was going to be extremely expensive. So that was reason enough to go after it. But the second one's the one we just talked about. You're also going to self-censor. You're going to move away from providing better programming. The 9/11 documentary, the programs like that, where you know that they're going to be
Saving Private Ryan,
where words are going to be used that you're not going to go down that road. And there may be some people in this country who would prefer to have network broadcasting be available so that basically 6-year-olds can enjoy it at all hours of the day and night. But that's not I don't think that's a sustainable system because the broadcasters have to compete against the cable operators and everybody else. So instead of carving out a set of presentations that are suitable for children, what you'll end up with is you'll just drive the broadcasters out of business.
Kim Hart.
Because of all of the new competition for broadcasters out there, does this indirectly or directly kind of force the broadcasters to push the envelope a little bit more on this era to make sure that you are appealing to certain audiences?
There will always be some of that, I suspect. I think there's no question that there's a little more provocative broadcasting, and there probably will be somewhat more. But my basic point is, though, from the experience from the 11 p.m. to 6 a.m. that it's not open season, because even if you're pushing some, you still recognize that your audience is different from the core of the audience that on cable. You know, cable people are looking for certain visual images that you just don't expect to see, or certain language that you're not going to expect to see on broadcast. So I think there'll be a move, but it's not. There's an inherent constraint on it.
Carter Phillips, there's this footnote in the case on page 18. Although the remand order also found the broadcasts in question profane, the FCC has abandoned that finding for the purposes of this appeal and has relied solely on its finding of indecency. Any significance to that?
It's a funny exchange there. The statute makes it a crime for anyone to utter an obscenity and anything obscene, indecent, or profane on radio. And profanity has historically been blasphemy, which candidly would raise probably even more profound First Amendment issues under the Establishment and Free Exercise Clause than it would under just pure speech. The Commission, for some reason, in defense of its change in policy with respect to indecency, sort of tried to reinforce the indecency by saying that it's not only indecent, but it's also profane. The problem with that is that just means that they now interpret profanity to be exactly the same as indecency, and I think they recognized as much, and so they decided not to defend on that ground.
And any effect on radio on this decision? With this
yeah,
decision?
I mean, this is every bit as, oh, sure.
Okay.
Yeah, I mean, because the Pacifica case was a radio case. Yeah.
Kim Hart, last question.
Do you think that our society's idea of what constitutes indecent has evolved over the past 2 decades?
Well, you know, I think the trickier part about that question is just trying to imagine what is patently offensive to the under community standards. I mean, I don't know what I've never understood how the Commission thinks it can determine community standards, but I have no doubt that those standards have changed. Mm-hmm. You can't go to a sporting event without hearing language that, at least when I was a kid, you didn't hear very often, or maybe if you did, half of the crowd would scream, "Hey, there are kids in here." Mm-hmm. Now, occasionally you'll hear that. So, I mean, there's been a fundamental change in people's willingness and I understand some may be unenthusiastic about the coarsening of language in our country, but I don't see it changing anytime soon.
Carter Phillips is or was the attorney for Fox Television in this indecency case. Thank you for being on the Communicators.
It's my pleasure.
Coming up next, we're going to talk with another attorney, Pat Trueman, who was the counsel or filed an amicus brief on behalf of Focus and the Family on the other side of this issue. We'll be right back. Pat Trueman, what were your arguments in favor of the decency standards that the FCC has developed?
Well, when you look at this whole issue of indecency, you have to put it in context. It only applies to broadcast television, not cable. So my argument is that, or part of my argument is that people who are using only broadcast television and exclude cable, as I did when my kids were growing up, have a reason for doing that. Because there are standards on broadcast television, but there are no standards on cable because the indecency law doesn't apply there. So people have a reasonable expectation in their own home to be free from utterances of profanity or depictions of indecency. So that's why the use of the F word in my home, we don't allow it there, and I don't want someone like rock star Bono from another country to come into my home and say that word. I don't want Janet Jackson to bare her breast in my home. Now, the kids are older, so now we have cable, and if I have a cable movie on at 8 o'clock at night in prime time, I might expect that there would be that kind of material. But when I had just broadcast television, or even when I'm only watching broadcast television, or families do and they're not watching cable, they have a right to the protection in their own home of their family from that kind of language. And by the way, that's what broadcasters sign up for. They're on the public airwaves, as I argued. The public airwaves belong to the public, not to the broadcasters. And they actually agree, when they get their license, to treat families, the consumers, in a certain way. That is, they won't, I forget the exact language, but that they will use language that's in the public interest or programming that's in the public interest. And no one would think or be confused about the use of the F word in someone's home. It's not thought to be in the public interest.
Well, in their decision, the three judges on the Second Circuit Court of Appeals wrote that the observation that people will always find a way to subvert censorship laws may expose a certain futility in the FCC's crusade against indecent speech, but it does not provide a justification for implementing a vague, indiscernible standard.
Well, I disagree with that. I mean, this is what you'd expect, I guess, from a court in Manhattan. And as I said in a press release regarding this decision, this is one reason why people feel so out of touch with their government, that a court cannot figure out that the F word on broadcast television in the sanctity of our homes is inappropriate. Anybody can understand that. If I went into your home and I said in front of your wife and kids at the dinner table, by the way, I use the F word a lot. Do you mind if I use it? I mean, it would be a silly question. And rock star Bono has no right to come into my home and use that. Now, the court, you noticed, did not strike down the federal statute on broadcast indecency or profanity. That merely says that it's a violation of federal law to broadcast indecency or profanity. So if the regulations are vague, isn't that very language vague? I mean, what is profanity? What is indecency? Isn't that the question that people are asking? The court didn't strike down the statute, it struck down the policy. So if one is vague, the other likely is. But of course, it didn't strike down the statute because the Supreme Court has already upheld the statute.
Kim Hart of the Politico is joining in the questioning.
So is it your fear that as a result of this decision that came out this week, that networks who have, and some may argue, have been continually pushing to be edgier and edgier in both non-scripted and scripted shows will now be unrestrained and can do whatever they want?
Well, let's just go back a couple of years. The networks themselves used to have a code of conduct, and they've abandoned that as they've gotten, as you say, edgier, because they want to compete with cable television. So they keep putting on language and depictions on television that are edgier. And of course, this is a green light to do more. Now, they're in a little bit of a quandary right now because this is just one circuit court. So, the FCC is free to enforce indecency law elsewhere, even though the regulations have been stricken by this court. Now, some would argue that's not necessarily the case. And I think the FCC would hold up enforcing indecency law until there is some clarification by a higher court. But there's no question, if the indecency regulations are stricken, or the law itself is stricken, that you'll hear the F word constantly on any show, and you'll hear worse. Is that what people want? If they want that, they can get that on cable television. But consumers have a choice, and they choose to watch network television. And because that's on the public airwaves, they have a right to expect a standard of decency.
But on the other hand, from a business case, since, as you said, the networks are trying to compete with cable, they have a reason to need to air certain programming to make sure that they are making money just so they can stay around and survive on those public airwaves to continue their mission. So does that mean that they should not be able to be a little edgier or try to push the envelope a little bit from a business standpoint?
Well, two things. First of all, the standard only applies during certain hours when children are expected to be in the audience or people who don't want that kind of material. After 10 o'clock at night, they can air what they want in terms of indecency because the FCC regulations don't apply. But of course, the mindset of Hollywood is such that they think in order to get an audience, they have to constantly deviate down. Maybe they should rethink their position and go up a little bit, try to have more uplifting program. They don't have to say the F word constantly to get an audience. You don't have to bare your breast during the Super Bowl to get an audience. The audience is there. So, and if the networks want that kind of material, buy a cable station.
So what does this do, Pat Trueman, to the decency regulations that the FCC has developed? What happens to those?
Well, there are two cases on this. The second one is in the Third Circuit. in Philadelphia. That's the Janet Jackson Super Bowl case. I suspect that'll be decided soon. One or both of these cases will be appealed to the United States Supreme Court, and it'll be decided there.
And who will do the appealing? You think the FCC will?
Well, the FCC should. I would doubt that they would avoid that responsibility because, of course, the public cannot appeal that. The FCC has to do that. Now,
and Carter Phillips, who we talked to earlier, the lawyer for Fox, says he doubts, or he'd be doubtful that the FCC would pursue it to the Supreme Court.
Well, I question that. If this case isn't appealed, surely the Janet Jackson Super Bowl case will be appealed. So one case or another will get up there. And I suspect the same issue will be in either case. It'll be the constitutionality of these regulations that apply the federal statute on indecency. I mean, I would have a hard time believing, after all the hundreds of thousands of complaints that the FCC received on the Janet Jackson matter, that they wouldn't appeal that. I mean, you have to recall that that upset Congress so much that they then increased the fines for broadcast television by tenfold.
To 325,000?
Yes, 325 or 7,000, because Congress is so outraged. So the FCC pretty much has to appeal it. So it will get to the Supreme Court, I have no doubt about that.
Do you see any impact coming up on the political landscape? It's an election year. This could upset a lot of conservative voters out there. Do you see this playing into and how the FCC reacts going forward and how voters view candidates?
Well, the FCC, like all federal agencies, has a certain mix of politics involved in its decisions. After all, under the jurisdiction of Michael Powell, when he was FCC chairman, he refused to bring in indecency cases. And that's just his political views. He thought money was better spent elsewhere, but the complaints kept rolling in. So now the FCC is faced with a decision, and I think that they'll likely hold off as long as possible to see what the Third Circuit decides. And I can see their decision coming down at any time. Then you've got two decisions to look at. And one way or another, I think, when that one comes down, they will have to appeal. But I think that the public isn't as upset about this because they haven't heard so much about it. They will be upset when the Third Circuit says that it was appropriate for Janet Jackson to bare her breast during the halftime of the Super Bowl. And I think the Third Circuit is probably going to say, not that specifically, but they're going to do something to say that that was not inappropriate, and that will upset the public.
But Pat Trueman, do you think that broadcasters have an extra special duty during live broadcasts which they don't have control over?
Well, it isn't much of a responsibility to have a 4-second delay, which would have caught Bono or these other utterances of the F word. And so that's a responsibility that they do have in order to meet their obligations under their licensing agreement with the federal government to broadcast on the public airwaves. They have to broadcast in the public interest, and the public doesn't expect that the F word would be shouted into their home. And so that's not much of a burden, and they can meet that burden. The technology is there.
Kim Hart.
At the same time, there has been the argument that the public's idea of what is indecent has changed over the past several decades. That, yes, coarser language is now being used. People of all ages are more accustomed to different kinds of images. So do you think that that should play a role in how broadcasters view the content that they...
Well, of course, I think that the FCC does take that into account somewhat. They bring relatively few enforcement actions on indecency and certainly on profanity. But despite the fact that the standards may have changed somewhat, using the F word in someone's living room with children possibly present is always going to be profane or indecent. Bearing the breast of a female, you know, in the halftime of the Super Bowl is always going to be unexpected and indecent. So the standards aren't going to change in your lifetime to allow that sort of thing. And the networks know that. They know that. They push the envelope on some of these shows to see what they can get away with, and they've gotten away with a lot. I mean, look at what's on primetime television in the evenings. A lot of parents are upset with it.
Mm-hmm. Carter Phillips, in talking with him earlier, says that he thinks that this Second Circuit Court of Appeals decision brings us back to the Pacifica George Carlin case of 1978 that John Paul Stevens wrote the majority opinion in. Do you agree with that?
Well, I think it will, because the Supreme Court, when they hear this, has already decided the administrative issues and said it was proper for the FCC to issue these regulations, and it said the only question remaining is the constitutional issue, which they're not going to look at. They sent it back down to see if this regime of enforcement was constitutional, and now the court said it's not. So the court's likely to hear it. The Supreme Court is.
How do you define community standards, and are your community standards necessarily the same as everybody else's?
No, certainly mine, in my neighborhood, it's not my community, it's the community in which I live. I think that if you asked people in most communities in America, if you got a survey of them and said, is it all right to shout the F word on primetime television, on broadcast television, not cable, people would say that's not all right. If you asked them, is some sexual innuendo all right, they'd probably say yes in most communities. Now, there are some communities where the F word's probably fine. Maybe Manhattan, where this court resides. But I think most people would say not in my living room during prime time. And I think, so the community standards are evolving. There's no question that they're evolving. More is tolerated, but there's certain things that probably aren't going to be tolerated throughout the country. And when the broadcast networks broadcast in 50 states in every community, their standards would dictate that the F word's off limits.
What did you think of Chairman Janikowski's statement after this Second Circuit Court of Appeals decision?
He said what?
He just said, well, we'll have to weigh this and look at all the different issues, basically.
I heard something to that effect. I didn't hear his specific words. But what is there to weigh? I mean, he's supposed to defend the FCC policy. It's not an unreasonable policy to say that the F word or profanity, I mean, they're following the federal statute, which prohibits indecency or profanity on broadcast television. So to weigh it, I mean, it'd be a pretty quick decision. You have to appeal it.
And the statement's actually right here. We're reviewing the court's decision in light of our commitment to protect children, empower parents, and uphold the First Amendment. You said that you think the FCC needs to appeal, and yet in the decision made mention to the fact that the FCC failed to adequately explain why it had changed its nearly 30-year policy on fleeting expletives. How can the FCC going forward be more specific on that?
Well, first of all, the FCC over the years has been a bit up and down on their policy. As I said, during the tenure of Chairman Michael Powell, they did next to nothing, and the networks were racing ahead to put whatever they could on television that might be indecent or profane. But then, on the chairman that followed him, he was very clear about what the policy is.
Kevin Martin.
Kevin Martin. And in fact, the networks complained that his new policy was inappropriately instituted, and the Supreme Court heard that case and said, no, it was fine. 5-4 decision, but they upheld it. So the FCC has put out whatever they can put out on this. Now, they still have been uneven in their enforcement. They don't go after every utterance of the F word. For example, they allowed Private Ryan, Saving Private Ryan, to be on during prime time. Now, that's a great film, one of my favorite, but it's filled with the F word. And so why do that and cause the confusion when they could have just as well said it's okay to put it on after 10 o'clock at night when there's no indecency enforcement or profanity enforcement. But, you know, when they let one go and not another, that does cause some confusion. But in this case, I think that the Second Circuit dealt with Bono in the Golden Globe Awards. You know, parents don't expect to sit down with their children and watch that and hear someone shout the F word at them. And so it's reasonable to assume that that's not allowed.
Pat Trueman is the former chief of the Child Exploitation and Obscenity section of the Criminal Division of the U.S. Department of Justice under President George H.W. Bush, correct?
And Ronald Reagan.
And Ronald Reagan. So, last question, Kim Hart.
What do you think about bona fide news broadcasts that, in many opinions, are in the public interest to air whatever a political candidate or a government official may say?
Well, I would agree with the FCC on that. It's hard to regulate a spontaneous news broadcast. Now, if it's a news special and there's lots of profanity, they might have an obligation there. But when you're out interviewing someone and they live and they say the F word, you might not be expected to anticipate that.
Pat Trueman, who filed a legal brief on behalf of Focus on the Family and the Family Research Council with regard to the Second Circuit Court of Appeals decision in the indecency case. Thank you for being with us on the Communicators.
Thank you.
Kim Hart, Politico.
Thank you.
As always, we appreciate it. And by the way, if you go to our website at cspan.org, we will have linked to our site, to the Communicator site, the court decision and the amicus brief that was filed by Mr. Trueman and his groups, and Julius Janikowski's statement as well. Thanks for joining us on the Communicators.